Thanks, Jordan. Thank you all for coming here. What I've done is I've put together a few slides because it tends to be easier to show slides than screenshots at times, but I don't want to be bound by that. So if people have questions along the way, feel free to let me know. And otherwise, I hope to have plenty of time at the end for open questions about things that I'm doing with chilling effects. Right now I'm teaching as a visiting professor at Brooklyn Law School. Before that I was a staff attorney at Electronic Frontier Foundation. And throughout the whole time I've been concerned about the problems of the takedown of online speech and the legal threats to it. And so the Chilling Effects Clearinghouse over at chillingeffects.org is one response that we've put together over the years to help people resist those threats and to help warm the air for online speech. Yes, clearing the air for online speech. At Google and for many of the rest of us, the internet seems like a wonderful tool for information sharing and for gaining access to the information that we and other people make available online. Google, of course, does great things to help people make information available with search, with tools like Blogger and groups that make it easier for people to express themselves online. And of course, there are others who aren't so happy about the flourishing of expression online, who see it as a competitive threat, that others are able to discuss their products and places that they might find better prices or better deals, or talk about companies in ways that don't portray the companies in the best light. And so some people see this internet expression as something to be fought against rather than something to be celebrated. And many of those people use cease and desist letters, legal nastygrams against the content that they find online and to their distaste. Now, lots of these are just bluff. Lots of people send letters wanting something taken down and misstate the law, know the law but misapply it, claiming that a website is infringing copyright when in fact it's merely posting a photograph and commenting on it and making a fair non-commercial use of an image. Some of them are malicious. Some people find that sending a legal threat is a great denial of service attack against their competitors. If they can send a claim of copyright infringement to an internet service provider, that's far more effective than sending a gentle request that you please talk about my company in a better light. Plenty of bullying going on, and not to go too far, there's also plenty of unlawful activity online and plenty of people who use legal threats and cease and desist letters to get that unlawful activity taken down. And yet, whether the legal demand is correct or incorrect is not so often correlated with whether people respond to it. Many people are silenced by cease and desist letters, even if those letters are overbroad and make claims of sorts that the law wouldn't support. Because they don't know their rights, because they don't have a lawyer, because they don't have the resources to hire a lawyer, because they don't think that their little personal website is worth hiring a lawyer about, because they're risk averse, because they get scared of the consequences of legal action. They see something coming in on letterhead and don't want to face lawyers in court. And then finally, some of these cease and desist letters are sent not to the individual who's posted the material, but to their internet service provider or their internet search provider, because the Digital Millennium Copyright Act Safe Harbor, that I'll get to in a bit, encourages the sending of cease and desist notices to internet search service providers and the providers of information location tools, including this one here. And in that case, the poster and the internet service provider and the internet search provider don't all share the same incentives. While the individual who's posted the material may be very interested in having that material stay online and stay findable by the world, for the internet service provider, it's one of thousands of customers, perhaps not even a paying customer. For the internet search provider, it's just one of millions of websites that appears in the search results, and the cost of further investigation and fighting takedown demands may be more than it's worth to allow that one additional site to remain public. So the chilling effect site we set up to help these people and anyone who is curious about the law and concerned about the law and its impact on free expression to understand how the law actually applies to their online conduct and what their legal rights are in response to cease and desist letters they might receive. So Chilling Effects started it up around 2002. It's a collaboration among Electronic Frontier Foundation and law school clinics around the country, so law students get some real practical experience analyzing cease and desist letters that come in and the legal problems that they face. And among our hopes is that students who've worked with the project go out to become lawyers who have a well-rounded sense of the threats and benefits of online conduct. So if you get a cease and desist letter, you can come to chillingeffects.org. So a few years ago, somebody who called himself IboPet hacked his robotic dog. Sony's Ibo hacked the memory stick and found a way to make his dog dance a few new dances, and posted this online so that others could share in this excellent feat of reverse engineering and the fun new things that he could do with his Ibo toy. Well, of course, I say of course as a lawyer because as a lawyer I come to expect that the response to anything fun and innovative will be at some point down the line a legal threat. Sorry. Sony's response is to send a cease and desist letter arguing that reverse engineering the format of the memory stick and the programming for Ibo's dance movements is a violation of the Digital Millennium Copyright Act anti-circumvention provisions, because part of what Sony says they were doing with their formatting of the memory stick was copy protecting the dance moves in their programming, copyrightable material. The DMCA forbids hacking access control measures and trafficking in the technology to hack access or copy control measures. So Sony claims, take this down, you've circumvented our copy protections and redistributed some of Sony's copyrighted works. Well, if you're confused when you get one of these letters, you can come to the Chilling Effects site, report receiving a cease and desist notice, brings you to a web form here where you can enter in information about the notice and about yourself. And not quite that quickly, but after filling out the form, it goes out to one of the law school clinics where students add these annotations to the notice. Each one of these yellow highlighted points links to some frequently asked questions and answers on the Chilling Effect site. Copyrighted software with links over to some explanations about what kinds of things are copyrightable and what kind of copying is permitted. Sony claims that this infringes its rights. What are the rights of the copyright holder? What are some of the exceptions in even the DMCA anti-circumvention provision has a few exceptions. It doesn't ban absolutely everything, and among those exceptions is an exception for reverse engineering for interoperability, which it's quite likely that this reverse engineering would have fallen into. And so here, some of the frequently asked questions and answers below. And we build up a collection of these FAQs so that as new letters come in, we can tag them with references to these FAQs. And you can also just go to the site and browse what are all of the questions and answers in the reverse engineering or anti-circumvention section. So even if you haven't received a cease and desist letter, you can find more information there. And then after this, Ibo Pet posted on his website, Ibo going to law school to learn to read EULAs. So another of Sony's claims was that this reverse engineering violated their end user license agreement that at some point during the process of getting the Ibo working, they claim you would have had to agree to. So we're aiming to make the legal process more comprehensible, maybe not down to the level that a robotic dog could understand, but at least so that users of the internet can get a better sense of what their rights are and make informed choices about whether they want to comply with a takedown demand or respond to or leave the website up and wait to see whether the lawyers will do anything more than simply filing a complaint. So how does this tie in with Google? Well, Google is an information location tool provider, and as such, it gets complaints from people who don't like some of the information that may be located through the information location tool. So early on, several years ago now, the Church of Scientology complained about a website operating at xenu.net, the Operation Clambake site, that posted criticisms of Scientology, found Scientology's theology of alien invasions to be rather implausible, and posted some of that theology, the writings of L. Ron Hubbard, along with their criticisms of it on a website, along with some of the more modern material that Scientology had produced to try to recruit others to its religion. And Operation Clambake posted this material to help people make educated decisions about whether they believed the tenets of Scientology. Well, in their posts, they included quotations of the Scientology material, and that was enough for Scientology to make a copyright infringement claim against them, claiming that they had copied Scientology's copyrighted material, and thus they claimed were infringing copyrights held by the Church of Scientology. Now, if you go all the way through the copyright analysis, that's highly likely a fair use of the copyrighted material. Copyright infringement, too, has its exceptions, and one of the most important is the exception for fair use, including for educational, commentary, and critical and news reporting purposes. Fair use looks at things like the nature of the use that's being made, and the transformative nature. So a site that's using snippets in quotation for the context purpose of criticizing is quite likely to be a fair use. A site that simply ripped off all of L. Ron Hubbard's books to save you the cost of buying them in a bookstore probably would be infringement. But Scientology saw this, a copyright claim, as a nice way to make their critics less visible, so sent a copyright infringement claim and sent it to Google as an information location tool provider, and Google's response was to remove the links to preserve its safe harbor status under the DMCA. But in order not simply to remove it and disappear it with no record of what had been done, they chose to send the complaint over to Chilling Effects and then to link to Chilling Effects in the bottom of the search. So on this search for Scientology leaflets, you get the notice at the bottom that in response to a complaint we received under the Digital Millennium Copyright Act, we've removed 7 results from the page. If you wish, you may read the DMCA complaint for these removed results. And clicking on Read the DMCA complaint brings you right over to the Chilling Effects page where you can read the complaint that's been made and even read the URLs that Scientology has demanded be banned from the search index because the Digital Millennium Copyright Act requires that you indicate with specificity the location of materials that you want removed from a search index. And Chilling Effects feels that for completeness, we include the entire complaint that's been made, including all of those URLs that have been included.
Isn't the cease and desist letter itself copyright?
Sure. Everything under the sun that is original and fixed in a tangible medium of expression is protected from the outset by copyright. We no longer require registration of the copyright in order to protect it. But here too, we are relying on fair use. We think that there is a thin copyright in that letter that you've sent with the text of your threat in it, but the public interest in access to the texts of legal threats that have been made and information about the legal threats that have been made, we think warrants publication. And although we've had lots of people send cease and desist letters with little footers at the bottom that claim this letter is copyrighted, you may not reproduce it without permission, nobody's brought us to court over that. So I think I should skip ahead for a moment to some of the mechanics of the Digital Millennium Copyright Act. The DMCA sets up a safe harbor for internet service providers who fit any of these categories, the transitory digital network communications, caching, information residing on systems or networks at the direction of users, being web and file hosts, and information location tools, search engines. And the way that the law is set up is to say that as a trade-off between the ISPs and the copyright holders, saying if ISPs follow certain notice and takedown procedures, they can't be held liable for money damages for the copyright infringement done by their users. So it's saying there may be copyright infringement out there, but if you, when you're given notice of infringing material, expeditiously take it down or disable access, then you won't be held liable. Now, if you notice the way the law is set up, it doesn't say you will be liable if you don't follow these procedures. It simply says you can be sued, and that lawsuit would work its way to completion, and at the end, the judge would determine, if you hadn't settled it earlier, whether merely hosting material or merely providing a link to material claimed to infringe a copyright was enough to make you responsible for that copyright infringement. And in many cases, like the automated provision of a link to material that at the end of the day infringes a copyright, I think a search engine wouldn't be liable for providing that link. But the safest way not to get entangled in lots of litigation, which is costly even if you win in the end, is to remove the material expeditiously on notice of a claimed infringement, and so that's what most ISPs and most search providers do. They set up the procedure that the DMCA requires, designate an agent for service of process with the Copyright Office, and accept these notices claiming copyright infringement, and then upon obtaining such notice or awareness, act expeditiously to remove or disable access to the material that's claimed to infringe. So that's for hosting providers. For information location providers, the situation is similar. They shall not be so they're explicitly excluded from liability for referring or linking users to an online location containing infringing material or infringing activity if they respond expeditiously to remove or disable access to the material that's been identified specifically enough. And so there are sort of tremendous incentives in this system to send the Copyright Office your notice of a DMCA agent and to accept the notice and takedowns, and then to remove material when you get these claims of infringement. And for the ISP and the copyright claimant, that works out pretty well. For the individual whose material has been removed, it works out a little less well. The law specifies things like you must leave the material down for 10 to 14 business days if you want to claim the safe harbor, and the requirements of the DMCA counter notification are more onerous than the requirements of the initial DMCA notification. Do people have questions at this point, or want to see a selection of other funny and amusing cease and desist letters?
Are the letters, CND letters that are sent, sometimes they're misleading, or sometimes they misuse the laws? Isn't that illegal in itself?
Is it illegal to misuse the law or to make false claims? But there's a wide spectrum of misleading and false, but in the DMCA context, there is a specific provision, 512F, that gives us a pretty good way of going after claims, false claims of copyright infringement. So let me briefly tell the Debold story, which happened around the elections a couple of years ago, when electronic voting was becoming a hot issue, and a group of email messages leaked out from Debold with things like, the admission that testing releases go out to customers when they shouldn't, and new features get added to stable branches of the code when they shouldn't. Sometimes a bug slips into a stable branch, things that wouldn't give you an awful lot of confidence in the security of electronic voting machines. As those messages got out, people like the Indie Media Organization, students at Swarthmore College posted them to their websites, and citizen journalists started analyzing them, and newspapers and magazines started analyzing them, talking about insecurities in electronic voting that these revealed. One of them, another of them said things like the certification requirements require that voting machines run a system test as they start up. Our machine doesn't run a system test. That's why we've got this little batch file in here that prints out system test complete when it runs a memory test. Again, not exactly the sort of thing you want counting your votes in an election. And so students posted them, Indie Media posted them. What do you think Debold's response was? Well, DMCA, these email notice messages are our copyrighted property. And it has come to our attention that you appear to be hosting a website that contains Debold property. And they sent those takedown notices to Swarthmore College, to Online Policy Group that was hosting the Indie Media server that was linking to the emails on yet another server. And when Online Policy Group said, no, we won't force our customer to remove the link to the materials, they went up to Online Policy Group's upstream ISP, Hurricane Electric, with yet another DMCA complaint. At this point, I was with Electronic Frontier Foundation, and at this point, we decided to sue Debold for knowingly materially misleading claims of copyright infringement. With that, the judge agreed with us that no reasonable copyright holder could have believed that the portions of the email archive discussing possible technical problems were protected by copyright. And so in that case, Debold ended up paying our clients damages and attorney's fees for Online Policy Group and for the Swarthmore students who'd had to take down their website.
But this is an interesting case, but I don't think it's actually responsive to the question. I think the question was, really, are there any sanctions against intentional misrepresentation of the law?
And I'm saying that in this case, the law provides specific sanctions for misrepresenting a claim of copyright under the Digital Millennium Copyright Act, and I am using this example to make the counterpoint that in most cases there are no remedies. If you are not in a contractual relationship, or you can make an ethics complaint to the bar, and you might be able to, if you're economically harmed enough by the conduct, make some claims, but there is not a general cause of action.
Suppose we are in a situation where Hurricane Electric did take down the content fraudulently, and the DSA listened to the copyright claim and all this. Who would be who would these Swarthmore students sue? I mean, who is liable for falsely taking down content under false pretense?
Yeah, so we sued Debold for making the misrepresentations. In most cases, hosting providers will have contracts with their end users that basically allow them to do anything they like and say, you may not hold us liable. It's generally going to be a matter of contract, and unless you have a lot of money and a very powerfully drafted contract on your side, the average person is going to have a contract that says we can take down whenever we like, and for any cause or no cause at all.
So someone issues a cease and desist to Google for posting a link to copyrighted material. Cease and desist goes to Chilling Effects, and now Chilling Effects is hosting a link to copyrighted material. Why don't they then go after Chilling Effects?
Interesting question. Nobody has chosen to send a takedown notice to Chilling Effects in that way, claiming that we're providing information location tools that are leading people to copyrighted material. Only a couple of people have complained about the letters that we're posting, and even they have gone away after we remind them that we are a nonprofit organization of 7 law schools plus Electronic Frontier Foundation.
So do you think these people, I mean, obviously these people have proven that they're sort of reckless in their aggressiveness. Are they just scared of creating bad law? Or like why, if they are so recklessly aggressive, why aren't they doing the same thing to you? Do you think it's just that it's a bad PR move for them? Or?
Yes. It could be partly legal strategy, partly PR. Question, why aren't they threatening Chilling Effects? I think it's still the case that a lot of cease and desist letters are sent out because it's cheap and easy, and because it has a high compliance rate. So if you see your company being criticized and want to get some of that criticism taken down, send a letter claiming it infringes your trademark to use your company name on a website. And if most people comply, that's a pretty cheap and easy remedy. Going out and sending a second round of letters or suing is more expensive, and by the time it gets to that point, many people recognize that it's not worth their while. Another of the aims of the site is to show people that even that first degree of sending the letters has costs, that sending an overbroad or silly cease and desist letter will make you look silly and isn't something that will overall enhance your brand reputation. And I think people are starting to get that message too. Did I see a question back here?
So for the Scientology example, if it was clearly fair use, why would people take the links down for this?
Well, that's more a question for your lawyers than for me. But there are lots of reasons that a provider might decide to remove links after making just an initial investigation. Yes, there appears to be something here. It might simply be expensive to look through every page that's claimed to infringe to determine whether there's an infringement at the other end.
Has anyone tried harassing the DMC letter senders? Because it seems like you have 14 days window, so you could just take stuff down for 14 days and immediately put it back up and require that they continually send the DMCA letters, right? Would that be legal, or that you would still be protected under safe harbor?
The service provider would be protected by the safe harbor if it allowed people to put things up 10 to 14 days later. But we also, and if they receive a counter notification, we also see very few counter notifications, which is another, we're trying to puzzle out why it is that so few people sort of take advantage even of the limited rights that the DMCA gives them. Part of it's the difficulty of swearing to jurisdiction in a U.S. court, particularly for folks like the Operation Clambake, who are located outside the United States. They might not want to send a counter notification agreeing to U.S. jurisdiction. There's more room for thinking about creative ways to work with the DMCA process.
Do you have numbers on how many letters Chilling Effects sees and how many of them turn into actual lawsuits?
Well, let's see, I've got someplace in here numbers of DMCA notices that we've seen, and perhaps I can pull that up. So here's notices that Google has forwarded to Chilling Effects has risen dramatically over the last few years, up to 642 in 2006. Very few of them ever see even counter notifications, and very few of them become court cases. And that could be for a range of reasons. It could be that this material really was infringing and the infringer doesn't want to test his luck by filing a counter notification. And by no means, when I put up all of these numbers, am I claiming that most of them were illegitimate. A huge number of these are talking about pages that are just going out and slurping up somebody else's content and putting it on a site and trying to steal traffic. But there are also a bunch of them that are not, and instead are people engaged in political commentary, a blogger who borrows an opponent's campaign logo in a post that's talking about the opponent gets a takedown notice because that campaign logo was copyrighted. So we get a mix of those things.
Does Chilling Effects take a view on whether copyright law in general is in need of a reform, or is the goal to sort of say, here's the existing framework of copyright law, and let's sort of arm the public with information so that they can navigate their way through the system?
So does Chilling Effects take a view? No. Chilling Effects, I mean, as a website, is trying to be a relatively neutral discussion of the law, and within the context of current copyright law, pushing at the bounds of fair use for commentary and cultural discussion and criticism, but not a wholesale reform. Other organizations, other projects at some of these law school clinics, other projects at EFF, other things that I'm involved in, all do work towards the reform of copyright and changes to the law to make some of these abuses less likely and to make it easier for people to engage in fair discussion, even when that discussion involves copyrighted material.
Is there any comment made about whether they're good or bad notices?
On the website, we tend not to do that because there are complex rules about the practice of law and the giving of legal advice. And the site can't give legal advice to everyone who sends in a notice. And so instead of trying to do that, we do these analyses to help people draw their own conclusions. Again, some of us write papers or weblog entries or other things, and some of the weather reports on the Chilling Effects site do describe some of these issues and take more opinionated stances. But that's the line that we're trying to walk.
Is there any requirement that you notify the person who, or try to find the person who actually created the content, created the copied content to begin with, or can you just notify the ISP and Google and Yahoo and make it disappear?
When you send a DMCA notification to the internet service provider or the search provider, there's no requirement that you notify the individual or try to. Google, in its DMCA request form, I believe, asks the person who's sending the complaint to identify the person who's on the other end of it, so that Google, I hope, is trying to notify that person that a complaint has been made against his or her content. But otherwise, the DMCA tends to push the dispute sort of out, and the individual might not learn about it until he sees that his content has disappeared or is no longer ranked. Let's grab a few more of the things that we've gotten lately at Chilling Effects. One of the amusing ones recently was the Federation of American Scientists put together the site reallyready.org to criticize the job that the government was doing with its website ready.gov. Sorry. Here's ready.gov. And Federation of American Scientists thought that they weren't doing such a great job with ready.gov and put together this analysis at reallyready.org telling you here's how you can be really prepared in the event of a national disaster. And yet again, we get this time our federal government, Department of Homeland Security, choosing to address this not by improving the content on their ready.gov website, but by claiming that their trademark interests in the terms ready and Ready America and a green and orange checkbox means that Federation of American Scientists can't post this critical website because it will cause confusion as between the government website and their own.
I know it works by the government unless produced by contractors. We're not covered by copyright.
That is correct. This is a trademark claim that they're making, and the government can own
Can't have trademarks?
it can own trademarks, and it can even own copyrights if they're transferred to it. So you're right. That's probably why there's not also a copyright claim in here. But
if it's trademark, is it covered by DMCA?
Sorry, this is not DMCA now. This is just a cease and desist letter sent to the Federation of American Scientists directly. You're right. Sometimes we see people misusing the DMCA to send trademark complaints, but for the most part, the trademark complaints are sent directly to the individuals on the other end. So this one, DHS tells them they can't be really ready, and they send back a letter saying, sorry, even trademark has its exceptions, and one of them is for the use to refer back to the original organization, and we think nobody is likely to be confused by the provenance of this site. A claim I agree with. That doesn't stop other folks from sending silly cease and desist letters. So a few years ago, the Republican Party of Texas sent a cease and desist letter against the website that had Enron owns the GOP, taking the Enron logo and the elephant logo. Here too, we get a trademark claim. You have misappropriated our elephant logo and caused people to believe that, or potentially caused people to believe that Enron and the GOP are really associated. Please stop that. If anyone really believed that, they have more problems than just a trademark infringement from this little website. Guess who was not too pleased about this picture of Lynn Cheney? At whitehouse.org, the Office of the Vice President has sent a nice, friendly cease and desist letter to the owners of whitehouse.org claiming misuse of the presidential seal. The presidential seal doesn't really have a vulture in the middle of it. And misuse of an image of the vice president's wife.
Doesn't really wear a clown nose?
How do trademark dilution claims fit into sort of your view of these cease and desist letters? Because there, aren't you trying to protect something slightly different than like pure misappropriation for trademark?
Okay, so trademark dilution is relatively new law on the federal level protecting famous brands against dilution of their mark or source identification value. And that pre-dilution trademark has been used to protect source identification against consumer confusion. So nobody else can call their beverage Coca-Cola or bottle it in a red bottle with a swirl, because then consumers wouldn't know which they were getting when they went to the shelf to pick one up. Dilution goes beyond that to say nobody can call anything else Coca-Cola, because if somebody saw a Coca-Cola piano, then they'd have to think twice every time they saw the word Coca-Cola, wondering what it was that Coca-Cola referred to. So famous brands get this protection against dilution. I think that dilution claims then get overused because if somebody has made a mark and are used to shut down all sorts of interesting parodies and other kinds of commentary. My personal feeling is that if somebody has made a mark part of the language by attaining fame for his brand, then the public is entitled to criticize that and to use that in parody because that's the give and take of becoming famous. So, yes, please be aware that the U.S. Code prohibits knowing reproduction of any likeness of the seal of the president, except as for the official use of the government, and they didn't think that vulture seal was approved. The Onion has gotten a similar notice over its rebroadcasts of presidential speeches, again for misuse of the official seal. Again, is this the best way for the federal government to be spending our taxpayers' money? Here's another DMCA claim. Remember during the last election, the photograph that appeared and was circulating of John Kerry and Jane Fonda. John Kerry sitting at an anti-war rally where Jane Fonda was speaking, and bloggers and other commentators were circulating this photograph and discussing it, and some using it to claim that this showed that John Kerry was really a radical who shouldn't be trusted. Others to say this showed that other people were misrepresenting the photograph because it really there were all sorts of people there, and being pictured in this photograph didn't mean anything about your political leanings, and certainly not about your current political leanings. Here, the photographer who took this picture started complaining to websites everywhere, not necessarily about the political content of their sites, but about the fact that they weren't paying for the right to reproduce his photograph. So here he was sending DMCA complaints to folks, including Google, for hosting the Blogger service, demanding the removal of that picture from various websites that were using it. And here too, I think people could have raised fair use claims if the individuals had wanted to counter-notify for the use of this image in a non-commercial political discussion, but in most cases, they simply removed it. The last point I wanted to note on things that the Chilling Effects project is doing beyond the receiving U.S. and analyzing U.S.-based cease and desist notices. We've got these varied goals of helping people to understand and know their rights, helping people to understand the costs of sending cease and desist letters, researching these problems. We've also got some interesting things, because beyond sending us the takedown notices that they receive in the United States, Google also uses these same links or similar links in its international searches. Now, the United States, no matter DMCA aside, the United States is a pretty good place to be an internet service provider or web host. You're insulated from liability for most state law claims that somebody might make against content that's posted. Section 230 of the Communications Decency Act says you're not liable for user-posted defamation. And so, in most cases, ISPs and search providers can just ignore those complaints. Abroad, the law is less clear, and there are all sorts of regulations that foreign nationals might call upon asking for information to be removed. In Germany, there are laws against various kinds of pornographic content, against hate speech, against speech that glorifies the Nazi Party, against defamation. And so lots of people come to international versions of the Google search and find results removed. And here too, they can link over to the Chilling Effect site and not see the same level of detail, but they can find at least that it wasn't just that results disappeared, but that a German regulatory body in this case has demanded removal of material on body modification. And so the last bit of fun that we've had over at Chilling Effects is linking people over to a little search comparator where they can run the results of that search in both the google.de and google.com sites side by side and see that there is some difference to those searches and start to figure out what's being censored from their search results. Just since January 1st of this year, so in 8 or 9 days, more than 50,000 people linked over to Chilling Effects from international sites that had something removed from them. So there are the most being from Germany, Belgium, and then France. So there are lots of places where people have even less access to content than here in the United States. And Chilling Effects is hoping to bring a little bit more transparency to those removal processes. So I think I will, since it's getting to the end of time, I will let anybody leave who's getting anxious or hungry. Happy to take further questions.
There are law firms like ambulance chasers who specialize in silly insurance claims. There are other law firms that seem to specialize in silly patent claims. Is there a growing business of firms that specialize in silly copyright or cease-and-desist letters?
Specialize in sending silly cease-and-desist letters or in responding to them?
Well, sending them and doing this sort of thing. In the same way, is there a parallel to patent law where we've got essentially patent trolls that are doing silly things?
We've got I haven't identified any trends. I haven't identified any law firms that seem to be immune from sending silly claims or any that seem to be sending a whole lot too many. There are also the search engine optimizers who have found that sending cease and desist letters is a good way to get other people bumped out of the search results. So our friends at Mere Internet have sent a whole lot of claims against websites that clogged up their clients' search results, and they want people removed for potential customers are searching for on the internet, being their claimed copied phrase. And they found that, hey, if the search engine removes our competitors, we get listed higher.
So are these the only people that seem to be doing that in a concerted manner, or are there others as well?
It's hard to identify because we don't have a big enough set of all of the claims being sent and received. and it's hard to get other internet service providers to give us information. So I should absolutely thank Google for being as so open with the information that it sends on to Chilling Effects. I think it's something that benefits searchers using the Google search engine and researchers trying to figure out what's happening here. That people get to see why it is that their search results are being reshaped from the most relevant material. But it's hard to get others to follow in those steps to give us more data to see the scope of the problem.
I have a question that's probably beyond the scope of what Chilling Effects is targeted towards, but my roommate, who is a Broadway performer, so famous in that regard, had someone develop a MySpace page pretending to be her and posting personal information about her, like her location where she lived, and things like that. How is it possible to be protected against just going out and saying, oh, you know, I'm Alyssa Milana and I live here and all this, you know?
So she might have claims under, or somebody in that situation might have claims under defamation and privacy laws. Defamation, if somebody is making false statements about her, claiming to be her, sounds like a false statement.
Towards the person that created it, not the person, not MySpace, for example.
That's right. MySpace is protected by the CDA 230 provision from any liability under the defamation or privacy laws. So the claim would have to be directly against the individual. Now, it's also possible that not a legal threat, but a general complaint of your site is contributing to the misrepresentation of my identity. While I know I don't have a legal claim against you, as a general good practice, don't you think you should remove this? Might work better than misstated legal threats. Most sites don't have an interest in contributing.
Publishing the address would be against the law in some countries like Europe, right? Couldn't you try to use a European venue to shut down the U.S. site?
If a European court wanted to take jurisdiction over that kind of claim.
I guess MySpace.
But yeah, I think from what I've read outside this context, I think there are. I think that bands and other celebrities and other and even not so celebrities have had success just asking MySpace to remove misrepresenting pages. Well, maybe we can turn off the mics, and I'm still happy to chat with other people about other related questions. Thank you.